I know there's a lot of interest in how the mediation sessions went this week, and I, like you, am waiting for an official result to be announced through the official channels. However, I was able to attend the mediation sessions this week, and I wanted to share my thoughts with you. I'm unable to talk about what happened during the mediation, but I did record my thoughts prior to the sessions beginning on Monday morning. So I am at liberty to share those with you since they don't involve any of the confidential contents of the mediation discussions. So here you go. I hope you find it helpful. Welcome to Mediation Monday. It's a big day in the Celsius case. The loans ad hoc, along with the debtors, the UCC, and the Earn Ad-Hoc are going to be meeting before Judge Wiles in the Southern District of New York Bankruptcy Court. And the objective is to reach a settlement with the loans ad hoc. So as you may recall, in the initial version of the plan, there was going to be the prospect of loans customers potentially over a 5 or 6 year period recouping 85 or even potentially 100% of their collateral by paying a higher interest rate. Even though the higher interest rate was a problem for many folks, it was attractive to the loans people because they want their in-kind collateral back. Now we're looking at loans collateral being treated the same as earn. And understandably, if you thought you were going to get 85 or even more of your collateral back in kind, that would be a tough pill to swallow. So we're now dealing with this mediation. And after having a discussion with a couple members of the Earn Ad-Hoc, I will be in attendance today as well. I anticipate my role being more passive, observational. If I can help in terms of brainstorming solutions, potentially, happy to do so. From the perspective of an Earn person, effectively loans collateral and earns deposits were commingled. They were treated the same way within Celsius. So the question is, on what basis would loans collateral deserve a better treatment? And it seems like those arguments would come down to contract law, but that gets confusing because Celsius operated in so many different jurisdictions. I think over 100 countries, almost all U.S. states, except for those that they were kind of kicked out of. There's just a huge legal challenge in terms of dealing with all those permutations and all the different statutes. One of the arguments prior to, obviously, the mediation occurring is that the UCC's position of subordinating sell claims as they would be a security, that could also apply to Earn potentially, since the SCC is alleging that Earn is a security. And I think it is important to look at that in more detail. I know that's a question that a lot of creditors have. And sell is very different in terms of what it is versus Earn accounts. So with sell, you have the company itself issuing this token out of whole cloth. They're sending it to folks that are participating in the ICO, and it's trading in various kind of fly-by-night outfits. FTX was the most prominent exchange that it eventually got listed in. I think that occurred because they had acquired Liquid Exchange. So you have this token whose value can only be supported by Celsius being a viable entity. And you can also have sell within an Earn account, which would that be a double security? You get double subordinated. If we look at Earn itself, you're depositing your assets, which you own, onto the platform, and Celsius owes you back what you deposited, right? That does not change. It would be manifestly unfair to subordinate you getting back your own property, right? That's why I say in the context of sell itself, giving back the sell token seems entirely appropriate, even if they happen to be securities. But when it comes to Earn, The notion of it being a security is based upon Celsius's ability to earn yield on those assets. So they're going to potentially rehypothecate, lend out, use on their own behalf in order to generate a return and then pass that on to you. Simply calling interest rewards and telling your ambassadors never to say interest doesn't change what it actually is. So I think it is reasonable to think of Earn as a security, but to me, that's the earning component, right? They're taking your assets and they're going to earn a return on it. There's also arguments against Earn being a security or applying the same penalties that would occur were it be determined as a security. Securities laws are here to defend the consumers. It seems like it may be part of the loans group's strategy to use the arguments that the UCC presented for Cell Token and adopt them in order to use as leverage for their own position. If we compare loans collateral to Earn, we should draw out some very careful distinctions here. So to take out a loan, you needed to deposit through Earn, with the small exception of U.S. consumers after April 15th, who took out a loan within that 60-day window roughly. The underlying collateral wouldn't move. They still invested loan collateral the same way they invested Earn deposits. So there wasn't an underlying change in terms of the blockchain activity. Now, this harkens back to the custody issue, where if you deposited onto the platform after April 15th, your funds would go into the commingled wallet. So they'd filter into what they call your bridge address. It's your personalized deposit address. And that would get siphoned into what's labeled in Etherscan as wallet number 5. That's just a general commingled account. So effectively, your funds filtered into Earn accounts when you deposited into custody as a U.S. user. So when I was tracing through the blockchain transactions, I saw this behavior, and it felt like it wasn't upholding their obligations to implement custody. Now, because they held a separate custody wallet, which was underfunded in terms of their obligations, it held about 65% of the Ether they were obligated to have as of the pause on June 12th. That's problematic because if they had maintained their obligations of 100% coverage over their custody obligations, they would have had to pause the platform earlier, which means there would be more funds available for everybody left behind. So the longer they cheated the system to keep the platform going, the less there is available for everybody else. So they should have closed the platform earlier when they recognized they had what they called an asset liability mismatch. FTX uses a margin position. Celsius uses asset liability mismatch. These are just coded words for the fraud they were perpetuating. As soon as they're insolvent, they had an obligation to stop the platform to minimize the damage, because by facilitating withdrawals for people, they're getting made whole at the expense of people left behind. If you took out a loan, you had to, the vast majority of cases, come through an Earn account. And when you took out your loan, your collateral didn't move on the blockchain. The custody relationship was upheld by the court because they had both the legal writing to defend that type of contract, and they had good enough effort on the blockchain to manifest it. Now, when you come to loans, there is a wallet labeled as loans in Etherscan, but the collateral is treated the same way as Earn. It's a different situation from custody because of that element. Like, they're not saying we're going to custody your collateral. They're saying we're going to earn funds on your collateral. And the vast majority of interest rates are 1% or less. So if you're offering interest rate at sub-inflation, you're not effectively earning money on those loans directly. They were using the collateral to earn funds. As an Earn customer, you have the right to withdraw their deposits at any time, whereas a loans person doesn't have the right to withdraw their collateral until they pay down a loan. So you actually have less access to your collateral. You're taking on the same underlying risk, whether you knew it or not. Your collateral is just as at risk as earned deposits. They're both being used in Celsius's reckless way of borrowing stable coins against Bitcoin, giving them to untrustworthy third parties. Same risks involved with each. It's not like they just lost the earn deposits, even though they're all commingled and you can't tell apart which was a loan's collateral and which was an earned deposit. Loans holders also have the risk of liquidation. So it is more risky in that you can't access your collateral the same way earns people could, and you could lose your collateral if the market crashes, whereas earn doesn't have that risk. So if the underlying assets are exposed to the same risks and you have effectively less ownership control over that crypto than earn, it does become hard to argue that you should have title over your assets with less control over them than earn. Now, there could be certain contract law. Like, I think all the loans arguments are going to hinge on contract law. So we'll see how that goes. I likely won't be able to talk about that. The whole point of recording this video in advance is to be able to discuss this without violating the NDA that I am expecting to have to sign to attend. But in terms of preparing for the meeting, I have been thinking about these issues, and I'm hoping that it will be helpful to some of you just to listen to the thought process so I can balance abiding by my non-disclosure agreement and also share perspective in terms of how the mediation will go. From my perspective, I just would like to have resolution. Earn can't keep being the piggy bank for everybody in this case. So if there's not an articulable distinction of why loans collateral should be treated differently in terms of the distribution when the underlying collateral was treated the same as earn, there needs to be a reason to give a superior outcome. But if you do give loans a superior outcome to earn, there's going to be a whole ton of liquidated collateral that if you needed to repatriate those loans and pay that out, it could be hundreds of millions more dollars coming out of earn's pockets. Now, one potential resolution that I think could be effective would be if, rather than the set-off treatment, you could easily create a formula to penalize loans collateral to the same degree with the set-off treatment, but reformulate it to shave off the collateral to a certain percentage while keeping the loan intact to minimize the tax penalties for people that were borrowing against their coins. So that, I think, would be a useful way of negotiating. Trying to minimize the tax penalties, I think, goes a long way to address many of the loans folks' concerns. I'm hoping that we'll get close to laying out the outline of a settlement. And really, a lot of this does come down to loans' ability and willingness to negotiate in good faith. There has been some talk amongst certain outspoken members of loans that they have effectively leveraged to drag this out as long as possible, that they demand 100% in kind, that they could even get their loan principal back. If they could get the loan voided, they could keep their principal and would get 100% of their collateral back, which is a ludicrous proposition, that you would get, like, your assets are more encumbered than custody, who is observed to own title and who gave up 27.5%. You'd think that you would get not only 100% of your collateral, and you would get paid the principal of your loan effectively for the privilege. That seems like such an egregious breach of the equity standards of bankruptcy that I just don't see that happening. But effectively, the folks that are advocating to drag this out as long as possible, because it'll come at the expense of Earn, like, we're going to get ours, and Earn is going to pay for as long as this goes. All the fees are coming out of Earn because loans are going to get 100%. Like, that type of mentality is toxic and unhelpful. So I'm hoping that that viewpoint is not shared by many members of the loans community, because that's not conducive. And particularly if you're publicly expressing that your strategy is to drag this out, to bully Earn into accepting your terms, because the longer this drags out is coming out of Earn's pocket, that doesn't seem like a successful or good faith strategy for negotiating. So I'm hopeful that things will go well today. I'll, again, be limited in terms of what I can say about the meeting. But that's the whole purpose of recording this in advance, because now nobody can say I'm violating the terms of the NDA. Effectively, the negotiations have to be with loans because they're the ones that disagree with the current proposed plan. The upset amongst the loans folks is that they had the prospect of being able to keep their loans intact dangled in front of them for months, and now that's been yanked away. So I can understand that being painful. And there is also a lot of overlap. If you're in the loans group, the vast majority of loans folks also have substantial earned deposits. Thanks for listening in here. And now that I have recorded this, I'm going to get ready to go to the courthouse. I am not going to be able to wear this Traverse City t-shirt, and I'm going to now send a small transaction to the Helsius wallet. So I am probably going to switch to screen share here. I've loaded this up ahead of time, and I am sending this to Helsius, and I unfortunately need to dial in using my authenticator app. So I'm going to need to actually look up, I'm recording on my phone currently, so I'm going to need to use this to get the code here. So I'm here on Coinbase, and I will continue via screen share. But thank you for watching, and I will catch you soon. All right, and we're sent. Thanks, everybody. Appreciate it.